Thank you. Good afternoon, everyone. It's a real honour to be here to speak to you, to this audience, which is, I think, significantly representative of those people who know about ECL. I'd like firstly to thank the organisers for allowing me in. I heard about this conference around 2 weeks ago, and I wrote frantically to the organisers saying, please can I come, and please can I come talk, and they were very gracious. I think they were surprised to see somebody from the UK trying to get into Europe. So I will speak to you briefly on, firstly, how and why we came to adopt extended collective licensing in the UK. I'll tell you something about how our system works in comparison to some of the other examples we've heard about today, and talk briefly about what I think is coming next. So let's begin with kind of the policy context and the case for extended collective licensing in the United Kingdom. And I think there are really kind of three driving factors for us. The first is simplification. ECL, as you're all familiar with, supports easier rights clearance. This should mean improved circulation of copyright works legally, better compliance with copyright law, and giving rights holders new opportunities to be remunerated for the use of their work. In the UK in 2011, we had a major review of our copyright framework, known as the Hargreaves Review, and one of the recommendations from that review was that we should introduce ECL as part of a series of reforms to our licensing framework. The second reason was really kind of about protection and legal clarification. As I think has been alluded to, I think it's Vivica who made a comment on this point. In the UK, certainly, we knew of some CMOs who were effectively operating an extended collective license. They were licensing the works of non-members as well as members for quite practical reasons, but without any kind of formal legislative basis. This meant there was uncertainty for those CMOs about their business models in the event that a non-member came forward. There's uncertainty for users about the legal basis on which they're able to use works. And there's a lack of protection really for rights holders there. We have effectively outsiders or non-members whose works we knew were being used, but had no formal means to be recompensed or be able to opt out should they wish to do so. Finally, there's a modernisation aspect. We knew that increasingly users were interested in new high-volume uses of copyright works, such as mass digitisation projects in the cultural heritage sector, and we knew that ECL was a mechanism to support those. Of course, it came with significant concerns and really high levels of scepticism from some rights holders, particularly those rights holders in the UK where collective management was not a large part of how they licensed their rights. So for us, it was mainly the photography sector and the audiovisual sector. And they were really, there's a number of concerns listed here, but primarily they were concerned with the impact that extended collective licensing could have on their usual business models, the way they always manage their rights. They were particularly concerned that CMOs would start to kind of take over their primary licensing and take over the transactional individual licensing to which they were used. So we had a large volume of angry letters and complaints, and there was a previous attempt in 2009 to introduce ECL in the UK. That was actually thrown out at the parliamentary stage because of all the opposition that we had. So it was in the face of rights holders who needed some convincing. So here's the context where we worked. We developed ECL in the context of a deregulatory government agenda. The preference was for solutions that were led by the market rather than government imposing solutions on a particular sector, and you'll see how that affected the way we did it. We were very clear ECL should not be seen as a one-size-fits-all solution. There are some cases where ECL may be an appropriate solution to streamline the licensing framework. In other areas, a different solution would need to be found. We want to always make sure that when we legislate, our legislative approach is future-proofed and can deal with new technologies and new uses that might come forward in the future. And as I've said, we were legislating in the context of this previous failed attempt in the Digital Economy Act. This is the timeline we went through. After the Hargreaves Review, we consulted on proposals to introduce ECL in the UK. And in 2012, a bill was introduced to Parliament called the Enterprise and Regulatory Reform Bill, the ERR Bill, which gave us powers to establish ECL framework in the UK through regulations. At the same time, we launched a group of stakeholders to go through the real detail of what our ECL system would look like. I chaired that working group. It included a lot of organisations who were very hostile to ECL, and I still have many scars from that process. After that, we consulted in November 2013 on draft regulations, and those became law in October 2014. So we're now roughly 3 years since almost, and we have the regulations are 13 pages purely on the ECL system, so they go into some level of detail. So this is ECL framework. The UK system is based on a general ECL provision. We have no specific ECLs in our legislation. The thinking behind that is it shouldn't be for government to decide which areas are suitable for ECL. It should be for the rights holders through the collecting societies to come forward and suggest that this is an appropriate solution in this space. So essentially, where a CMO wants to extend a license and operate an extended collective licensing scheme, they will make an application to the government, to the Intellectual Property Office. There they need to include details of the license they want to extend and evidence of how they meet the requirements that are set out in our regulations. It's up to us to then assess that application. As part of that system, we'll always have a consultation period, so we'll allow interested parties, whether those are outsider rights holders, whether those are users, or anyone else with an interest to comment. If we approve the application, the ECL is authorised for a period of 5 years, and the CMO will need to reapply towards the end of that period if they wish to continue it. I'll move on to talk through the safeguards. There are quite a lot of safeguards in our system, which reflects I think the level of concern and scepticism from our rights holders in some sectors. So firstly, representativeness, quite familiar. We use significantly representative. Thinking about some of the comments earlier, I think it was Professor Ginsberg was talking about the link between representation and specific cases. We try and assess representation looking at the specific type of rights holder who will be affected. So it might be that we look at a subsection of a CMO's membership when we look at representation. We have a consent requirement. We actually ask the CMO to go out to their members and take a vote and say, do you as members support us making this application for ECL? The thinking behind that was that we're trying to get a sense of whether or not the outsiders would support it. And the members of a CMO who are members of broadly the same type as the outsiders and who have the same types of works should be able to fairly closely stand in for the interests of the outsiders. We have a requirement on conduct as well. It's important that an organisation running an ECL scheme has to operate to good standards, so they must state that they are compliant with the CRM directive and our implementation of the CRM directive in the UK. And of course, if we knew they weren't compliant from our enforcement work, we would not look kindly on that application. We have specific protections for non-members. The applicant must show that it has processes in place to try and inform non-members about the scheme. So they're required to publicise the scheme, and that could be internationally as well as nationally. And the applicant has to show that they have processes in place to try and find the outsiders and pay them. We think that those requirements are particularly important in the light of the Solier and Doak judgment. It's important that CMOs are making a genuine effort to locate the outsiders. All UK ECL schemes would have an opt-out. Put that down. Just going to ignore that. Oh, brilliant. So we believe that's really essential to ensure that ECL is compliant with international law. We've put in some specific requirements around the opt-out and how it must look. A CMO must acknowledge an opt-out request within 14 days. They must action the opt-out within 6 months. And they must make publicly available a list of those works who have been opted out. Royalties, very briefly, the CMO will collect the royalties as normal and try and locate non-members in order to find them. The obligations on distribution in the CRM directive also apply here, but there are specific ones, more stringent ones that apply where ECL is in place. Where a non-member can't be found after 3 years, at that point, under the CRM directive, it would normally be declared non-distributable income, and the members could choose what happens to that income. Where it's been collected under an ECL, we would usually require the CMO to hold it for a longer time to give non-members, outsiders, the chance to come forward. And after that, they may have to transfer that money to the government. So CMOs effectively can't just hang on to the money they take from outsiders and use it for their own purposes or spread it among the members. we think that's, again, another important protection for outsiders. So the future of ECL in the UK, I'm sad to say that in our 3 years since we passed the legislation, we've actually not had any applications to run the thing. Maybe that means nobody wants it, but I don't think that's the case. We have had a lot of discussions with CMOs and with users who are interested. I'm expecting the first application. I've been assured it will be coming next month. It was due last year. But I'm expecting the first application to come in very soon. I think the reason why there's been this delay is that people are getting used to the system. They're understanding the things they have to do to meet the safeguards. And I think people are a bit scared to go first. They know that the first couple of applications will be very closely looked at by the government, and I think people want to make sure that the CMOs want to make sure that everything is correct before they put an application in. The things we think it's going to be used for, I think the first couple of applications will be to deal with existing schemes which really already operate as ECLs and give them legal basis. There are also a number of potential schemes around mass digitalisation, I expect. We're finding that ECL, having the framework in the UK, is leading to more collaboration between CMOs, which is an interesting and useful development. The CMO representing works for reprographics and digital scanning has just taken on new members from visual arts CMOs, so we're seeing a broader representation start to grow. Rights holders now are a little bit happier about ECL in the UK. Now they've seen the regulations and see the safeguards we spoke about are real. I think that has assured them to some extent, but they're still watching us very carefully, and so we'll be very closely monitoring the impact of the first schemes as and when they come into effect. And as I say, we fully expect the first application to come next month. I'll just finish by talking briefly about the UK's approach to European developments in this area. We've already spoken today about the Commission's proposals to use a extended collective licensing type model to support the use of out-of-commerce works and making available of out-of-commerce works. We fully support that proposal. The UK's view is that we want to make sure that any solution is as practical as possible, so we are interested, for example, in whether or not the European proposal should include the works of third country nationals, and we want to make sure that any search that the Cultural Heritage Institution is required to do to declare a collection out of commerce is appropriate and isn't too burdensome. We also, I think, earlier today referred to a possible solution in the European directives to deal perhaps with the Solier and Doak case and any potential problems that throws up. The UK has been part of that. I've been working with colleagues in Denmark and in Sweden, and we've made a proposal for a new article in the current copyright directive. That would be a kind of positive declaration that says that member states can introduce extended collective licensing schemes at a national level. So going further than the existing recitals that we have, and having a positive statement about the availability of ECL as a solution. And in that scenario, we think it should be up to the member states to determine where ECL is appropriate and to ensure that in using ECL, they continue to make sure they meet any of their international law obligations. I'm aware, I think it's fair to say that the Commission is yet to be convinced by that proposal, but we will continue discussions on that, and it's really helpful to be having these types of discussions at a European level. That's all I wanted to say. Thank you for your patience, and thank you again for the invitation.